Lawyers of Reddit, what's your best, most badass, I rest my case moment?
I was on the losing end of this one. I was representing a pro bono defendant who was attempting to regain custody of her children. The family division attorney was laying out his case to the judge for why my client wasn't ready, and his final point was that my client had refused emotional counseling to avoid violent fits of rage that she had inflicted on her children. On cue, my client jumps up screaming, "Fuck you, judge lady. You a stupid cunt. Fuck y'all for taking my fucking kids, you fucking cunts." I just caught the opposing attorney's smirk of satisfaction as I got up to usher my client out of the courtroom. When I was in law school, I had to argue a case for an exam. I was the last in my class to go, so there wasn't anyone arguing against me. I opened with a motion to dismiss since opposing had failed to show. The judge grading me chuckled and said, "Touché, counsel." I still had to go forward, but we got off on the right foot, and I ended up with an A. Not a case-winning moment, but an emotion-winning one for sure. Think of cases like a big conflict, with motion hearings as little conflicts. Opposing attorney was insisting that Rule A meant they could do X. I tried multiple times to point out Rule A literally did not say that. During the hearing, the judge reached behind them, grabbed their rules of civil procedure, basically a dictionary of rules, placed it in front of the other attorney, and said, "Show me where Rule A says X." Other attorney did not take the hint, read rules out loud for a brutal 5 minutes, and gave the book back. I said, "Judge, I have nothing to add." It was pretty fun. Opposing counsel decided that I had coached my witness and gave him lines to repeat, that he was lying. Short version is that he asked the witness if he spoke to me before he testified. Witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him, what instructions I gave him. Witness looked him dead in the eye and said, "First thing he told me was to tell the truth no matter what." He said the lawyer is never the one who goes to jail, that he isn't going to jail for me, and if I lie, I'm on my own. Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. Only time I've smirked or laughed in court. I wanted to put my feet up on the table like I was Vincent LaGuardia Gambini, hands behind my head, and say, "I'm done with this guy." I was prosecuting some kid. He had an antisocial behavior order, which meant that he was not supposed to go to a certain street. He had pleaded not guilty on the basis that he had not been there. I opened my cross-examination by holding up a map and pointing at the street. I said to him, "You went here, didn't you?" He said, "Yes." In England, we don't say, "I rest my case." Instead, I looked up at the bench, said, "No further questions," and sat down. It might not seem badass, but I got the defendant to admit the offense with one question. That never happens. Corporate lawyer, so I don't have cases to rest. But once opposing counsel was forcefully insisting that it was ridiculous for me to expect a certain provision in a contract we were negotiating, and I pointed out that this provision was standard in his own firm's contract forms, as I knew from several prior transactions I'd worked on across from them. Pretty exciting stuff. He took it in stride and said, jokingly, "Well, of course it's fine when we ask for it." I represented a company that was sued for breach of contract by a former independent contractor. Dude basically alleged that my client wasn't paying him correctly in accordance with the contract. During his deposition, Dude admits that he never reviewed any documents to make sure his allegations were true, never reviewed his complaint before filing it to make sure the allegations in it were true, and had no idea whether or not my client actually failed to pay him in accordance with the contract. Basically, he tells me that he was suing my client because he didn't think their agreement was fair, even though he agreed to the terms when he signed the contract. The kicker is that he admitted that he owed my client money. At arbitration, he tries to flip his story and starts giving testimony that is the exact opposite of his DEP. So I whip out his transcript and undermine his testimony bit by bit. Needless to say, I won that case. Complaining witness accused my client of harassment, stalking, said she told him numerous times that she wanted nothing to do with him. My client claimed they were dating, but whenever she got mad at him, she'd call the police and say he was harassing her. On the stand, she testified that she'd never dated him, never invited him into her home, wanted nothing to do with him. She presented a photo on her phone of him sitting on her porch to prove that he had come to her property. I asked the judge permission to look at the photos before and after the porch photo for context. Girl had dozens of photos of the guy, who was clearly her boyfriend. I showed her one such picture. This is Mr. So-and-so, right? Yes. In this photo, he's on a bed? Yes. The bed is yours? Yes. The bed is in your bedroom? Yes. You took this photo of him? Yes. He's smiling in the photo? Yes. And in this photo, he's wearing your brassiere? Yes. No further questions, Your Honor. We had a case where opposing counsel was cross-examining our expert witness on hydrology regarding some silt runoff issues. Mr. Smith, wouldn't you agree that the book I'm holding is highly respected in your field and considered to be the gold standard on the subject? Witness, I am aware that it is highly regarded in my field. Would you be willing to explain, in your own words, what paragraphs 6 to 10 on page 121 is describing? Witness reads the passage word for word. Yes, I can read. But could you put this passage in your own words for the court? Witness, these are my own words. I wrote it. We were the defendants. We were being sued by an HOA over silt in a lake. We were able to prove that we weren't responsible and prevailed. It actually originated from another site and entered the lake, elsewhere. However, that site was owned by a very large corporation, and I don't think the HOA wanted to fight with an entity that could fight forever. One quick and one longer one. Lawyers might like the latter more. Asking a judge to place my client on probation with mental health treatment support and supervision as well as drug treatment for a few minor misdemeanors. DA is on board. Judge asks my client if he understands the plea deal, if his head is clear and he hasn't consumed any medicine or other thing that might cloud his judgment. Judges ask this to make sure pleas cannot be withdrawn. Client's response, "I'm high, bitch," and begins laughing his head off. Judge is incidentally an openly gay man with a bit of a temper. Judge screams at client, "SIT down," and multiple deputies run to the jury box, where my client is kept in custody, as the rest of the courtroom bursts out laughing. 2. Presiding, head, judge denied a motion of mine. It was a pitch-yes, which is a request that the judge review confidential police files for evidence of misconduct to use impeaching the officer. No, you don't get that stuff automatically, because police unions fight not to release it even when prosecutors, much less defense attorneys, ask for it. That's another topic. I filed a writ, which is a way to get an appellate court/division to look at issues in the case before the case is over. These are 1. A fair bit of work, and 2. Hardly ever granted. About 1/10 appeals are granted, and these are extraordinary for appeals. Writ granted. Judge reversed and ordered by the appellate court to grant the motion and dig through the dredges for officer misconduct. At the hearing on the remittitor, order by higher court for lower court to do something, the judge read the remittitor and then said something like, "Who would deny a pitch-yes?" With a bit of incredulity, I just stood there, smiling at him, as he flipped through the court minutes. "Oh, it was me." Eye contact. I'm pretty sure I was still grinning. Next handful of close call motions I had in front of him resulted in rulings in my favor. I wasn't a lawyer at the time. This was a high school mock trial, but it was fun nonetheless. For those unfamiliar, mock trials are like normal trials, but fake. As a result, it doesn't go until arguments are exhausted, but instead each participant is given a time limit and has to make their case within that period, so everyone can go home in a timely fashion. The time limit was 10 minutes for us. but you could go slightly over if needed. Anywhere, we were competing against a local school in a case that centered around an alleged hostile work environment. I was one of 3 attorneys doing direct examination in my team, and my witness, playing the company's CEO, happens to be a close friend of mine, so we were well prepared. At trial, I get through all my questions, passed across, and that's when the fun began. The opposing attorney got through about 6 questions before my friend gave an answer he didn't expect. Rather than simply moving on with his questions or jumping to another line of questions, opposing counsel chose to repeat his questions slightly differently, in a way it would have been proper for me to object to with asked and answered. I didn't. Instead, I sat there, silently, as this poor fucking kid spends his whole time trying and failing to get the specific answer he wants out of my friend. So, after 10 minutes of him restating his 6th question to no effect, I objected. The judge, sick of listening to the same question, said something to the effect of, "I would hope so. You spot my plan yet?" Rather than object the question had been asked and answered already, I simply stated the cross had used their full allotted time, and that he shouldn't be allowed to continue. Remember, he was 6 questions into his argument, so all he had gotten in his 10 minutes was confirmed my friend's name, age, place of work, job title, and that they had meetings at work. I shouldn't need to tell you none of that is particularly useful for proving a hostile work environment claim, but I did anyways. The opposing counsel looked very confused when he realized what had happened, and the judge, kindly, suggested he move past that question and finish his examination quickly. He moved on, got slightly further into his questions, but not far enough, and eventually had to stop due to time. Still nowhere near where he needed to get to. My score wasn't particularly high. After all, I missed an easy, asked and answered objection for 10 minutes, but higher than his, and we won as a result. Good times. Another mock trial story. Me and a different buddy were running late, and definitely stole a parking space from someone while attempting to make it inside quicker. Get inside, and the same dude whose parking spot I just stole walks in a minute or 2 after me. Turns out it was the judge who was presiding over our case that day. We lost that one, after the judge awarded bonus points to the other school. It was ostensibly for a very clever argument they made, but I maintain it was because he recognized me and my friend and was unhappy about the parking spot. So I rested one case with a sneaky trick and got another case RIP'd because of a parking dispute with the judge. And this is the end of today's video. I hope you liked it, and don't forget to comment an anecdote or experience similar to the topic of the video. Leave your like, share if you like the video, and lastly, don't forget to activate the little bell so you don't miss any of our daily videos. Bye-bye.